not for flavored products that differed from tobacco flavor.
FDA says, look, you should think hard and you should give us materials about flavors because that's one of the things that we're really going to be thinking about is flavors. And in your application, you talk about the role of flavors, right? That your application tries to show that if you have flavors, it's better at getting people to quit smoking, right? That's one of the points of your application. So I guess I'm not really seeing what the surprise is here or what the change is here. Like everybody basically knows that flavors are particularly dangerous in terms of kids starting the use of smoking products. And so, the countervailing benefit might be if flavors were also particularly good at getting adults to stop smoking. And that's basically what FDA told you, and it's basically what you tried to convince FDA of. And then at the end, FDA said, you haven't convinced us. We think flavors are really bad in terms of youth smoking, and we don't think that you've shown us that they provide any special benefits in terms of smoking cessation. So I guess I just don't see where the gap is here.
Well, Your Honor, this certainly wasn't called out at all, and certainly not with the level of specificity. And I would, respectfully dispute the fact that everybody knows this and everybody knows that.
Well, you know that FDA thinks that flavors. FDA has been completely upfront about this, and I think that the point, that flavors. You give people blueberry vapes. The difficulty with that, and FDA I think has tried to document this, is that blueberry vapes are very appealing to 16-year-olds, not to 40-year-olds.
I respectfully disagree, Your Honor. In fact, the literature review that respondents provided explained in detail that often the cessation journey for combustible cigarette smokers, be it
No, I'm not saying that you don't have a point of view on that question, but you knew what FDA's point of view on that question was that blueberry vapes are really problematic in terms of youth smoking. And that FDA was basically saying to you, so given that we think that, you've got to show us otherwise, that your product, your flavored product, is going to be particularly good at getting people to stop. There's just not a lot of mystery here about what FDA was doing. You might disagree with that because you think that, in fact, the world of 40-year-olds really wants to do blueberry vaping, but you can't say that FDA hasn't told you all about what it's thinking in this respect.
Well, going back to the 2020 enforcement guidance, which is a document that my friend points to as providing notice on this, the 2020 enforcement guidance doesn't speak, and I respectfully point the court to Judge Jones' dissent from the initial panel decision on this, and also to the Biddy decision out of the 11th Circuit. What that enforcement guidance speaks to is cartridge-based flavored products, and it talks at length about the device characteristics that make those particularly attractive to youth. Respondents' products have no history, zero history of youth usage. And that's the case if we look at the National Youth Tobacco Survey data from CDC, et cetera, all this literature that was in the applications. That's the case for bottled e-liquids generally. The devices with which they are used don't have any sort of a track record of being substantially attractive to youth, and nor then do the e-liquids.
I feel as though you're arguing the merits back to me, and if I encourage that, I apologize, because that's not what I was saying. What I was saying is that FDA has been completely upfront about what it thinks about the role of flavors here, and you knew that because you can tell it from your own application, that your application was geared to trying to convince the FDA that, notwithstanding what the FDA might think about how flavored products encourage youth smoking, there was a countervailing benefit in terms of encouraging, enabling adults to quit.
Your Honor, the FDA doesn't claim to have reviewed, or after the fact, post hoc rationalization, FDA claims this is what you set up to prove and this is how you proved it. They say in the marketing denial orders, we didn't look at anything except whether there was longitudinal comparative efficacy evidence. So I don't think they can hang their hat on that point after the fact. Had the applications been silent as that, it wouldn't have mattered. What FDA was looking for was this longitudinal comparative efficacy evidence. That's what the marketing denial orders show. That's what the technical project lead reports or reviews show as well. And so,
but isn't it your claim about notice? Just picking up